Ted Lieu is a former military lawyer. He has questioned war criminals. He has sat across from people trained to deceive under pressure and watched them try. He knows what it looks like when someone says something that is not true in a setting where the truth is required. And when he walked into that hearing room with 2 photographs and a witness statement, he was not there to ask questions he did not already know the answers to. He was there to build a case, step by step, document by document, until the moment when the Attorney General of the United States said something on camera that gave him what he came for. He started with the photographs. 2 photos of former Prince Andrew. Andrew had attended parties with Jeffrey Epstein. The photos documented his presence. Lieu held them up and asked Bondi a single question about them. Not about Andrew, not about the investigation, but about the redactions. Under the law Congress had passed governing the release of Epstein materials, the DOJ was permitted to redact photos to protect victims of Epstein's sex trafficking operation. Bondi had done that. She had redacted the face of a person in the photographs. Lieu asked her directly, "You redacted the victim's face because you were following congressional law. Is that correct?" Bondi confirmed it. Yes. Lieu nodded. Then he said something that reframed everything that followed. "You have now established that we are looking at a sex trafficking victim." The photographs were back on the screen, the redacted face visible, the confirmation on the record, and Lieu moved to the law. Under the Federal Trafficking Victims Protection Act, he said, not only is Epstein guilty, anyone who patronizes Epstein's sex operation is also guilty of a crime. That is the statute. That is what Congress passed. That is what the law says. And the photographs in front of the committee showed someone who, under that statute, had committed a crime. The significance of that legal framework cannot be overstated. Lieu was not making a moral argument. He was not expressing outrage or invoking public sentiment. He was applying a federal statute to documented evidence. The Federal Trafficking Victims Protection Act is explicit. Patronizing a sex trafficking operation is a federal crime. Epstein ran a sex trafficking operation. That is not a contested claim. It is the basis of his 2019 indictment and the foundation of Maxwell's conviction. Anyone who used that operation committed a crime under federal law. The photographs documented someone at events with Epstein. Bondi had just confirmed on the record that the person depicted alongside that individual was a sex trafficking victim. The statute, the photographs, and Bondi's own confirmation created a legal chain that led directly to one conclusion. There was evidence of a crime. Evidence sufficient, under the standard the DOJ itself uses, to predicate an investigation. And the July memo had said there was none. Which made what Bondi had done in July 2025 not just a policy decision. It made it a choice. Because in July 2025, the DOJ had issued a memo closing the case on Epstein's abusers. The memo stated in writing that the department had not uncovered evidence that could predicate an investigation against uncharged third parties. Lieu read those words back into the record. And then he pointed at the photographs still on the screen. These 2 photos staring you in the face are evidence of a crime. More than enough evidence to predicate an investigation against the person depicted in them. The memo said there was no evidence. The photographs said otherwise. Both things could not be true simultaneously. Why did you shut down this investigation last July? And why have you not prosecuted the person in these photographs? Bondi's response was to redirect. She referenced other attorneys general who had also failed to act on the Epstein files, noting that previous DOJ leadership under prior administrations had made similar decisions. Lieu did not argue with her. He agreed. "I agree with you," he said. He named the prior failures directly and without hesitation. A whole string of failures. But then he said the thing that made the redirect irrelevant. You are in charge. You have the power to change things, to hold these men accountable. And you're doing the opposite. You're protecting them. The exchange had already established the core of what Lieu was building, a statute that makes patronizing Epstein's operation a crime, photographs that document presence at events with Epstein, a July 2025 memo claiming no evidence existed to predicate an investigation, and photographic evidence sitting on the screen that contradicted that claim directly. He had what he needed. He moved to the next document. "Can I answer?" Bondi asked. Lieu said he wanted to move to another question. The moment was deliberate. He was not interested in Bondi's explanation for why the investigation had been closed. He was interested in what she would say next, because what she said next was what he had come for. He asked about another man who appeared throughout the Epstein files. He asked whether there had been any underage girls at parties this person attended with Jeffrey Epstein. Bondi's response was immediate. There is no evidence that a crime has been committed. Everyone knows that. Lieu looked at her. I got your answer, he said. You said there is no evidence. And then he held up another document. This is a witness statement, he said, from someone who called the FBI's National Threat Operations Center. This person had direct proximity to conversations between Epstein and the individual Lieu had just asked about. He had heard things that disturbed him enough to contact federal law enforcement. He had reported what he witnessed. He had reported meeting a woman who told him she had been raped. That woman was later found dead. Officers at the scene said the circumstances were inconsistent with suicide, and no one at the Department of Justice had ever interviewed this witness. Lieu looked directly at Bondi. I believe you just lied under oath. You said there is no evidence. This witness statement is evidence. It exists. It is documented. It has been in the federal system since it was reported to the FBI's National Threat Operations Center. And your department has never interviewed the person who made it. Bondi reacted. Don't you ever accuse me of a crime. Her voice carried real heat. The exchange had become something different now. Not the careful choreography of congressional oversight, but something raw, with both sides saying things that could not be unsaid. Lieu did not back down. I believe you just lied under oath, and this is all on videotape. He said it again with the camera running and the record open in a congressional hearing room in front of the committee, under conditions where everything said becomes permanent. This is what a congressional hearing looks like when the gap between what has been said officially and what the evidence shows becomes too wide to bridge with procedural language. Bondi had issued a memo in July saying there was no evidence. Lieu had a witness statement that constituted evidence. The statement had been in federal hands since it was reported. The DOJ had not acted on it. When Bondi said there was no evidence, she was either unaware of the statement, which would raise its own serious questions about how thoroughly the department had reviewed the materials, or she was aware of it and said there was no evidence anyway. Neither option was comfortable. Lieu named the less comfortable one on the record. The accusation, I believe you just lied under oath, is not one that gets made lightly in a congressional hearing room. The phrase carries legal weight. Lying under oath is perjury. It is a federal crime. A sitting congressman saying those words to a sitting cabinet member on camera in a formal proceeding is not a rhetorical flourish. It is a documented allegation in the permanent congressional record. Lieu said it twice. He said it the second time with the specific acknowledgement that it was all on videotape, a reminder not just to Bondi, but to every viewer watching that what was happening in that room was being preserved, that it would not disappear into the ordinary noise of a congressional session, that the gap between there is no evidence and the witness statement he was holding in his hand was now part of the official record of this hearing alongside both statements. And that record does not have an expiration date. There are over 1,000 sex trafficking victims in this case, Lieu said, and you have not held a single man accountable. Not one. Not the person in the photographs. Not anyone whose name appears in the flight logs or the visitor records or the witness testimony. The July memo said the evidence was insufficient. The photographs were evidence. The witness statement was evidence. The 302 documents naming individuals who victims say they were trafficked to were evidence. The FBI had been sitting on that evidence for years, and the July 2025 memo had closed the door on using any of it. Shame on you, Lieu said. If you had any decency, you would resign right after this hearing concludes. The chairman noted his time had expired. Bondi asked to respond. The chairman gave her the opportunity, and her response, pivoting to an unrelated crime in another congressman's district, did not address the witness statement, did not address the photographs, did not address the July memo, did not address the gap between no evidence and the documented evidence sitting on the table. It addressed none of it, which was itself an answer, though not the one anyone in that room would have accepted as sufficient. What Lieu established in that exchange cannot be walked back by a pivot or a personal attack or a procedural objection. He established it step by step, with each element building on the one before it. A law that makes patronizing Epstein's operation a crime. A set of photographs that document presence at Epstein events. A DOJ memo claiming no evidence existed to investigate. A direct contradiction between that memo and the photographs. A witness statement sitting in federal records, unreviewed, describing what a witness heard and saw and reported. A direct statement from the Attorney General that there was no evidence. And then the evidence itself, produced immediately after in real time in the room on camera. The photographs are in the record. The witness statement is in the record. The July memo is in the record. Bondi's statement that there is no evidence is in the record, and Lieu's response to that statement, "I believe you just lied under oath," is in the record. All of it permanent. All of it visible. All of it sitting alongside the question that has followed this case through every administration, every document release, every classified memo, every redaction, every closed investigation. How many people patronized Jeffrey Epstein's operation? How many of them have been charged? And why? With photographs and witness statements and FBI interview reports and flight logs and visitor records. The answer to that last question is still zero. Lieu said, "Shame on you." He said it knowing the cameras were running and the record was open and everything said in that room would outlast the hearing itself. He said it because 1,000 survivors have been waiting for someone in a position of power to say it to someone in a position of responsibility. He said it because the July memo closed an investigation that the evidence says should still be open. And he said it because sometimes the most precise legal argument available is the one that names, without euphemism, what the record shows. Not a misunderstanding, not a policy disagreement, not a difference of legal interpretation, a choice made deliberately by someone with the power to make a different one. And the photographs, and the witness statement, and the 1,000 victims without a single accountable man. Those are the consequences of that choice.